committee finds that he has a case to answer, he has to come back to the plenary. This now, the plenary sitting as the plenary.
Why can it go easy? You have lost us. Come back again, all right? On the allowing the deputy president to respond. I mean, just walk with me and the viewer. What are these two scenarios that we're looking at?
Let's start all over again.
Yes.
You saw the leader of majority in a committee, a special committee of 11 members to investigate the charges leveled against the deputy president by the National Assembly. Then after moving the motion, even though there were no names attached to it, ordinarily, they bring in the names, the motion with the names. We propose the following names to be in them. Somehow, I think it was predetermined that they were, but either way, it was determined. It was determined at the Senate at that point that there will be no committee being formed. Why? Because when he called Senator Edwin Sifuna for Nairobi to second it, he declined.
All right.
And let me tell you the politics of it. I think these are my personal deductions from this.
All right.
It's easy to handle a committee of 11 people. It's very easy, maybe perhaps, to manipulate, so to say, a committee of 11 people. But it's harder to manipulate 67 people. And manipulation can happen from either sides. So in this way, they chose to go to refuse the committee way and say now they need to do it as an entire house. And I think that is where we are. If they went the committee way, that's what I was explaining.
Yes.
If they chose the committee way, this committee of 11 would have called the deputy president to the investigation and explain to him the charges, give the National Assembly a chance to explain and expound the charges, and then have the deputy president defend himself, bring witnesses if he may, and then write a report to the plenary, to the entire house now, saying he has a case to answer or not. And now, because in this case, if he has a case to answer, he would be called back by the plenary.
All right.
He would be called back by the plenary so that the senators who never had a chance to interrogate him at the committee, those who are not sitting in the 11-member committee, would have a chance now to interrogate him at the plenary. Now, all that is water under the bridge because we know, as a fact, it's now sitting, the House is sitting as a committee of the whole House. So they will have a chance, the Deputy President, using his 5 hours, will have a chance to defend himself before each one of them. You answer their questions, you respond to every single of those, if you may, and try to convince them why they should not confirm the impeachment that was done at the National Assembly. That's where we are at the moment.
And during this, the lawyers and advocates will be allowed.
They will be allowed
in the session.
In the session, and they will share the minutes.
All right.
They will share the minutes, and there will be just the way the cases of governance happen when they're doing the Senate is conducting the impeachment trial. They will be able to respond to the allegations, and they have a band of documents which they are supposed to file by Monday, as per the timelines there.
Yes.
And every other legal team, whether it's from the National Assembly, they present them their documents, whether from the Senate, and then they'll use that to defend themselves at the Senate.
Indeed, and Fomba, even as you speak in, and I understand that even as Kenyans are watching this morning, there has always been a concern of witness protection. Now look at the office of a deputy president, and there have been jokes around. Remember when we had the discussions around Masengeli?
Yeah.
And there were concerns around who is going to arrest their boss. Now, that joke aside, who is going to have the courage, those have been questions, to witness against deputy president? How sure are we that this country protects such people, that this particular impeachment trial will be free, fair, and free of any prejudice? And of course, we're just seeing the images. They are coming to your screen shortly. Seeing the judges, the 3-judge bench is coming in, but those images will come in shortly. But let's just touch on this basis.
Before I get to that, I think I need to pick up from where my colleague has left on the decision by Senator Sifuna not to second the motion of the committee, of the 11-member committee. I think he wanted, or the Senate generally wanted to have
So unfortunately, the big day is here and the time has come, and I can see then the courts are commencing this particular hearing, if I may call it that, Wakili. Is it? Or is it a ruling? Okay, indeed. So I want us to cross over, as we should honorably do. It's happening right now, and listen in, and we might come back with the panel anytime from now. Let's cross over to Milimani Law Courts for the 3-judge bench verdict on the matter.
Good morning, Lord. Good morning. My name is Ntomo. I hold for Paul Wing Senior Counsel. Together, the team representing the first petitioner, that is Tom Masharia, Andrew Muge, Sakimpa, Faith White, and Victor Swine for the first petitioner. This we do not see how the second to 6. Your Lordship, my name is Gachagua Sanate for the second petition. I appear together with my other colleagues, Mr. Joe. In addition to that, I am holding a brief for Mr. Joe for the second to the 6th petitions. If it pleases the court for the second to 6th. If it pleases the court, in the matter, my name is Simon Mburu. I continue on record for the 8th.
Kwa niaba ya mzungumzaji namba 6, kwa jina naitwa Nepal na patana na
with the permission judges, there is a concern about members who are online. They said that they need to be unmuted so that they can participate in it.
Who appears for petitioner 10? Caroline Wombui. No.
For purposes of counsel who are online, are you able to hear us? If you are online and you are part of these proceedings, can you please say good morning?
Good morning, my name is
Thank you. Petition number 10. Then we'll go to the respondents.
Hello, my lady, this is the matter. My name is Medimo Benson. I do appear for the first respondent. Lord, I have the privilege of introducing my other colleagues. For the second respondent, my Lord, I, Milimo Conference for Mr. Nyamodi and Mr. Gumbo. For the third respondent, my Lord, my other colleague, Ms. Okola, present before you. All three for Ms. Kanji. For the third, fourth, and seventh respondents. And my Lord, my other colleague, Ms. Akama, is present before you. All three for Mr. Kuyoni. for the 5th respondent. And my vote I in Limo, call brief for Mr. Wanyama for the 6th respondent. And my vote for the 8th respondent, my last colleague, Mr. Kama, who is present before you, have been requested call brief for Mr. Vita, who appears for the 8th respondent.
For Mr. who?
Mr. Vita. For the 8th respondent. Another bill for the
Yes. Interested parties? Yes. So we are done. I think we are done with the quorum, unless somebody's name has not been recorded. I believe that you are ready to take the ruling pursuant to the applications which we had yesterday. This is the ruling in the consolidated applications, in the consolidated petitions. We have considered the submissions of the parties, the facts in those applications, and the arguments and submissions of parties, and we have prepared a ruling which will be perfected in the course of the day, but whose summary is as follows. We have given the facts of the proceedings, the relevant submissions and arguments, and for the purposes of today and this morning, because we don't have much time, we'll give you the abridged version of our ruling. Analysis: having carefully considered the applications, the responses, the party submissions, and the various decisions referred to, the court distills the following issues for determination. 1, whether the applications are res judicata. 2, depending on one above, whether the applications are merited. As to whether the applications are judicata, the nature and applicability of the doctrine of res judicata is a well-trodden path by the Kenyan courts. In petition numbers 42 and 43 of 2014, which were consolidated, that is Kenya Commercial Bank Limited versus Muri Coffee Estate Limited and another, the Supreme Court of Kenya, in an elaborate fashion, illustrated the operation of the doctrine of res judicata. We are not going to go into the details about the doctrine of res judicata, but we have considered it there. We have cited several cases in support of the arguments put forth by parties. And returning to the matter at hand, there is no contestation that the first petitioner herein regarding Gachagua filed and prosecuted an application seeking conservative orders in Nairobi High Court, constitutional petition number E 550 of 2024. On 15th of October 2024, His Lordship, Judge Muita delivered a ruling on that application. For reasons contained in that ruling, the application was dismissed. The nature of the conservative orders which were sought in the said Nairobi High Court Constitutional Petition number E 550 of 2024 related to various facets of the impeachment proceedings against the first petitioner in this case before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenge the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Mute, urged this court to nevertheless deal with the instant applications for the main reason that this court, as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise a restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gachagua Peter Munya versus Dixon Manda Githinji. And I've stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classical case of Gachagua Peter Munya, which I've said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also cited the case, the court in Wilson, Kaberia, Nkunja. You'll find them in our ruling. Having considered those, then what we then looked at are the elements for granting a conservative order. These are, we are giving them to you in point form, but we have discussed them in detail in our ruling, which we shall give. For the sake of completeness of the record, we have dealt with the merits of the application and whether conservative orders should issue. Whether prima facie case has been established. We take the view that the same has been established. The applications raised constitutional issues that require further judicial interrogation. Whether any prejudice will be suffered by the applicants. No prejudice if the applications are not granted at this stage. The process is a lawful constitutional process, and the Senate will conduct a trial where all the issues being raised before the court will be raised and determined. At the moment, we are being called upon to anticipate the outcome of a process yet to be completed. The application at this stage is premature and anticipatory. Should the petitioner not succeed, the petitioner still have an opportunity to approach the court after the process. The applications are not without a remedy. On the issue that has been raised that as soon as the Senate impeaches the DP, if at all that happens, that the DP immediately ceases holding office and he cannot reclaim office, we take the view that every office holder can only assume office legally and constitutionally. The assumption of office cannot oust the court's jurisdiction. The court has unfettered jurisdiction to check on the constitutionality of the process at whatever stage. Whether the grant or denial of the conservative order will enhance the constitutional values and objectives in the Bill of Rights. We find that exercising restraint at this stage will enhance and allow independent institutions of government to function unhindered and in their fullness, except in the clearest of cases. It is our view that this is not one such case where intervention is automatic. The issues raised by the parties will require to be interrogated. We therefore find that the enhancement of the constitutional principle of separation of powers will be best served by declining the application at this point. Whether the petition will be rendered nugatory, we find and hold that it will not. The petitions challenging the process of impeachment, the petitions are challenging the process of impeachment. The substratum of the petitions will not be lost. The court is still able to grant a remedy even after the process is conducted, even after the process is concluded, and as such, the court will not be acting in vain. On public interest, we find that the public interest tilts in favor of allowing the constitutional process to proceed unhindered. This position, therefore, deriving from the foregoing, the following final orders do issue. The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the ruling of the court.
Okay. As we wait about the ruling, about on behalf of my colleague, I know senior counsel major would have wished to do because I have the bar done. Your lordships, for the same time, taking a lot, knowing that you left here yesterday at around 9. Because I have no doubt that you might not have had some goodness. We want to thank you for allowing us to have argued before you yesterday and for your delivery of this topic within the time of my Lord. We will wish the Deputy President of the President for this. I thank you.
Thank you.
In the leadership on behalf of the first petitioner, this is Jomo for calling me for following this in the council for the first petitioner. I was noting that the proceedings before the Senate are actually now commenced at 9 a.m. We don't know the outcome of that particular process. But nevertheless, we would require that we appear before the lordships as soon as practically possible, and preferably if possible on the 15th of October this year, so that we can take directions for hearing.
A procedural motion for the alteration of the sitting time of the Senate for Wednesday, 16th and Thursday, 17th of October, 2024 was moved and approved to facilitate the impeachment hearing of the Deputy President of the Republic of Kenya. Subsequently, via the Gazette Notice number 13178, I notify the general public that pursuant to Article 145, subsection 3 of the Constitution, and Standing Order 781 of the Senate resolved to investigate the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, AGH, Deputy President of the Republic of Kenya, in plenary. Now, honorable senators, regarding the hearing and determination on the proposed removal from office by impeachment of the Deputy President, a program has been prepared and appended to today's order paper. As is the tradition, and in line with the schedule of activities for an impeachment hearing in plenary, the Senate will hold a closed-door preparatory session to deliberate on the management of the investigation. The objective of the preparatory session is to ensure that the process is conducted seamlessly, concluded timely, and in line with the requirements set out under the Constitution and the Senate standing orders. Honorable senators, during the pre-hearing, the parties, if they are present, all members of the public and the media will be expected to withdraw from the chamber and the galleries, and any form of broadcasting from the chamber shall cease forthwith. In accordance with the program for the impeachment hearing, the open session will commence at exactly 10 a.m. Consequently, I now direct all members of the public and the media to withdraw from the chamber and the galleries, and any form of broadcast from the chamber to cease forthwith. Kindly be guided accordingly. Thank you.
To launch documents manually, just in case the CTS will not be accessible like it was last week. Not only
Lord, on behalf of the nine petition nominated to pass, we got to name the petition taken from what transpired
Mr. Lempa, what are you saying?
I'm saying, my Lord, that we will seeking leave to amend the petition depending on what transpired at the Senate, and we will also associate ourselves with the submission of the case because of the challenging experience last and 6 years. If necessary, circumstances allows us to launch our documents.
Now, indeed, we have kept our word and we are following closely the events of the day as expected. And so far, we've seen the 3-judge bench that was constituted or appointed by the Chief Justice Martha Koome giving us their verdict on this matter. Remember that the Deputy President's team had, of course, given their submissions and requested and somewhat pray that the courts would stop the debate debating of the impeachment of the deputy president to even begin at the Senate. Now, so far, the Justices Eric Ogola, Anthony Mrima, and Frida Mugambi have declared their stand. And one of the things that, of course, have come out strongly is that the courts are still exercising their restraint. They will not interfere with the lawful process. And, of course, the other arms of government are pretty much doing what they ought to do, as is enshrined and allowed by the Constitution. Some of the things that the judges have also said is that the application by the deputy president came out as premature and anticipatory, and that they still have an opportunity, however, to approach the courts once this process goes to the Senate and is concluded and completed. They talked about the court will check the constitutionality of the process, as is something that we also said here with the panelists, and they will serve and hold dearly what the Constitution says around the process. But of course, that is what has happened at the corridors of justice, which then allows what you have just seen, the Senate, to pick up the impeachment process. And we have seen just before we exited the Senate, the Speaker of the Senate, Amason Kingi, also just putting the House in order, ready to begin this impeachment debate. We have a whole program that the Senate brought forth to the public yesterday, that is for today and on Thursday. But we continue to also sample your feedback. Remember that the judge has spoken about upholding public interest. We have legal voices in studio that will explain what does it mean, public interest. Maybe some are confusing it with public participation, but we'll get that clarity shortly. So the application so far, in a nutshell, by the deputy
Noting that the proceedings before the Senate are virtually now commenced at 9 a.m. We don't know the outcome of that particular process. But nevertheless, we would require that we appear before your lordships as soon as practically possible, and preferably, if possible, on the 15th of October this year, so that we can take directions for hearing of the petitions that are now pending.
18th of October is which day?
On Friday, this coming Friday. Senate proceedings, my lords, and your leadership will conclude tomorrow. We don't know what time, but hopefully at night. And it will be necessary that to protect the peace of the first petitioner, that we appear before you to take directions for hearing of the petitions. Again, my lords and your leadership, because of the unknown outcome of that particular process, it might be necessary for the first petitioner to amend the petition depending on the outcome of the inquiry. So at this point, at this juncture in time, we also pray for leave of the court that if necessary, we can amend our petition before we take the directions on Friday. If leave is granted, my lords, you can comply with the amendment process as soon as possible. If you grant us time, we'll be happy to appear before you on Friday so that this subject matter is not just. Thank you.
Your Lordship, my name is Gachagua Sanate for the 7th petition. Mine is just
Mr. Wathuta?
Yes, Judge.
Yes.
It's just more or less a housekeeping request.
From the chamber and the galleries, and any form of broadcasting from the chamber shall cease forthwith. In accordance with the program for the impeachment hearing, the open session will commence at exactly 10 a.m.
On behalf of the 9 petitions, my name is Lempa. We also seeking leave to amend the petition intended on what transpired at the Senate.
Mr. Lempa,
Yes,
what are you saying?
I am saying, my Lord, that we will be seeking leave to amend the petition
Unatazama Sound Candid Talk. Toa sauti yako usikike.